Good morning. Welcome to Discovery IAS Academy's online platform. Today we are here to discuss a very important as well as interesting topic for all of you, irrespective of the fields. Obviously, for civil services exam also it is very important. We know that neighbors don't change. We cannot change the neighbors. And whatever is happening in our neighborhood, that also creates sometimes very considerable impact. So, in the last couple of days, you must have read in the newspapers, you must have watched in TVs, news channels, the happenings, the crisis in Pakistan, and the new government taking over. And all of you must have been thinking about what could be the possible impact on India-Pakistan relationship. As I said, this is a topic which is interesting also, and it is extremely important from the viewpoint of India's diplomacy, from the viewpoint of our historical aspects, from the viewpoint of our social, cultural aspects. Therefore, we have decided to pick up this topic, that what has happened in Pakistan, which we should call, or whether we should call it, a constitutional crisis. And more importantly, we have to discuss the fate of democracy in India, in Pakistan especially. Why democracy? Because India and Pakistan, when they were created in 1947, both were democratic states. But while India adopted the bottom-up approach to democracy, Pakistan adopted the top-down approach. Both are parliamentary republics, both have common history, both have common culture to a greater extent. Still, democracy in India has matured over the period, while in Pakistan we have been noticing since 1947 that democratically elected governments have not been very successful for one reason or the other. And at number of occasions, Pakistan has been under martial law. That also you must have read, must have heard. So, considering all these things, it was very obvious to pick up this topic to bring to you the details of the constitutional crisis, if it is so, and the understanding of constitutional crisis, exactly, precisely, what exactly it is. And what could be the fate of democracy in Pakistan, and how this particular event would impact India-Pakistan relations, or whether it will impact. All these things need to be covered, and I am dead sure that you will find it useful for yourself, for your understanding also, and for your from your examination viewpoint and from your interest viewpoint. When we say constitutional crisis, crisis is a situation where conflicts, disputes are not resolved. This is very general meaning of a crisis. When it is constitutional crisis, that very precisely means that the constitution or the law of the land is unable to resolve a dispute or a conflict. It means constitution of any country it intends to resolve conflicts, because politics itself is a process of conflict resolution. Politics itself is a process of consensus building. Therefore, we say that constitution of any state should be able to resolve conflicts or disputes and settle down those disputes and contribute to the smooth functioning of the system, smooth functioning of the government. Whenever this does not happen, we say that the state is, or state has reeled into a political or a constitutional crisis. Now, it is not only Pakistan Off and on, in number of countries, such crises have taken place, have occurred, and somehow or the other, the countries have been able to resolve them. Pakistan has also been able to resolve by instituting a new government, but still, the issue of this crisis needs to be clarified, needs to be understood in terms of understanding the intricacies of the constitution of any state. Definitely, we are talking today about Pakistan's constitution. At the same time, in today's discussion, I will also try to highlight a comparative account or comparative study of the constitution of Pakistan and India. And we'll try to delve into the various provisions, and we'll try to find out the differences between the working systems of the two countries, the two neighbors. Despite the fact that they share, as I said, they share common history and they share common culture to a greater extent, still the constitutional systems of these two countries differ greatly with each other. So, first of all, I would like to highlight, or I would like to say that what is the definition of a constitutional crisis? I have written a problem or a conflict in the functioning of the government which the constitution fails to resolve. As I said, that when the law and the constitution is unable to settle down the disputes which might lead to the malfunctioning of the government, then that could be considered as constitutional crisis. There is another term which is also used sometimes, that is constitutional coup. This means when authorities grab power within the constitutional framework. That is called constitutional coup. It means the grabbing of the power is illegitimate, that we know. But that event or that action of the authority is blanketed by the constitutional provisions. That is called constitutional coup. And when the constitution is unable to resolve a conflict, that is called constitutional crisis. So there is a basic difference between a crisis and coup. This type of crisis may occur for so many reasons, which we also call the types of constitutional crisis on the basis of its origin. How did it origin? How did it come to the fore? So, first of all, we say that when the constitution is silent on a particular issue, that may lead to a crisis. Second is when a constitutional provision is in question and you need to interpret it. That is also one of the grounds which might lead to a crisis-like situation. The third is when the constitution tells to do something, but it is not politically feasible. There are provisions, and you feel theoretically that yes, it could have been done, but it is practically not possible by the politics, by the system, by the state to bring it into effect. That is also a kind of crisis. And finally, when the institutions fail, institutions like legislature, like executive, like judiciary, whichever. So when institutions fail, that also would lead to a crisis-like situation. So any of these grounds or any of these factors could lead to a constitutional crisis. Now let us understand these through certain examples. First of all, when the constitution is silent, if I explain that, in 1841, the then US President William Henry Harrison died. After his death, the Constitution did not tell about the role of the Vice President, and that Constitution remained silent about this until 1967. In 1967, the VP's role was clearly defined that in the event of President's death, he could take over as acting President. But at the time of President Harrison's death, it was a kind of constitutional crisis-like situation because the role of the Vice President was not clearly defined in the Constitution, and we say that Constitution remained silent on such issue. This led to a constitutional crisis as the Constitution was silent about the role of the Vice President. This was finally defined in 1967. So that is one example of constitutional crisis on the ground that the Constitution remains silent on a particular issue. The second is if the constitutional provision is in question or it needs an interpretation. That also comes from US. The example also comes from US. During 1930s, when US faced Great Depression, the Constitution or the provisions did not guide the state how could it deal with that kind of depression or that kind of situation. So it desperately needed interpretation, and then only it could have given the guidance to the state to deal with the, you can say, Great Depression-like situation. So this was the second time when we have a crisis-like situation in US again. That was when needs interpretation. This was during 1930s. Great Depression in the US. Constitutional provisions desperately needed interpretation to deal with this situation. This was also an example of a constitutional crisis. The third is when the Constitution tells something to do, but it is not practically or politically feasible. A more recent example we have from the US. When President George Bush had contested election against Al Gore, you must have remembered the irregularities noticed in Florida state. And when the constitutional experts looked at the provisions, they could find that the Constitution tells that the Congress should decide in this case. Now, on what basis Congress could have decided, that was not clear. So that led to again a crisis like situation, that the Constitution tells something that Congress must do this, but how Congress would do, that was not made clear, and the Congress was really confused what to do and what not to do. So it was in this expedient dilemma, what to do, what not to do, because the Constitution did not give clear-cut direction, and that way it did not appear to be politically or practically feasible. So that could have, or that had led to a kind of crisis again in the US. That way, when the Constitution tells something to do, but it is not practically feasible. So the third is something, but it is not politically feasible. That is, irregularities in presidential elections, as in the case of Florida. The Constitution empowers the Congress to decide, but does not give clear direction, and that could lead to a crisis-like situation in that sense. Then the fourth is when the institutions fail. This we can see in the recent Pakistan's constitutional crisis in 2022, when National Assembly was dissolved and the Supreme Court took the suo motu cognizance or suo motu action, and people have started criticizing that Supreme Court had violated the Constitution by interfering in parliamentary proceedings, and that has violated the basic fundamental principle of federation, that is separation of powers. So people have started, or the critics have pointed out, that the judiciary and the legislature both have failed to resolve a conflict, and that had led to the constitutional crisis. Violation of the or we can say alleged violation of the Constitution by legislature and the judiciary. So these are the examples of, we say, constitutional crisis in US and in Pakistan. different types of constitutional crisis. There are a number of examples in the country and in the world. For example, in Australia in 1975, when the Prime Minister was suddenly dismissed, that has also led to a kind of constitutional crisis which is oftenly called the dismissal. Then we had in 1950s, we had a crisis in South Africa when the state wanted to separate the electorates on the racial grounds. And in Malawi also in 2012, when the president died, it was not notified and the cabinet continued. So all these examples are there to understand what exactly is meant by constitutional crisis. And once again, the definition, if I tell, then when the constitution fails to resolve a dispute or a conflict that leads to a kind of constitutional crisis. This is what the introduction of the crisis. Now, coming to Pakistan, which is our prime topic, and as I said, it is very interesting. Pakistan is a federal Islamic parliamentary republic. That is the nature of the state. Now, let us talk about this. Federal Islamic parliamentary republic. So when we say Islamic, it is a theocratic state. It has the Islam as a state religion. So it is not secular. It has a state religion. Now this federal Islamic parliamentary republic of Pakistan has its motto, Iman, Ittihad and Nazam. That is, in English we call it faith, unity and discipline. When you say faith, what is faith? Faith is the zenith of belief. Belief, when it loses rationality, that is converted into faith. Means, as I said, that belief, when it reaches its zenith, how to recognize that it has touched the zenith? When it loses rationality, then it turns into faith. So when you have faith, and that's why we say that religion is a matter of faith. Our Supreme Court also tells this, that religion is a matter of faith. You must have read in constitutional studies that Commissioner HRE versus LT Swamiyar 1954 case, the Supreme Court held that religion is a matter of faith. So we do not use rationality in general when we deal with the religious affairs or religious practices also. So the motto of Pakistan's Federal Islamic Parliamentary Republic is faith, unity and discipline, and faith reflects its belief at the zenith towards religion. So politics is related to religion, that is very clear from its motto itself. When you compare India's motto, which is truth alone triumphs, that is Satyamev Jayate. When you say truth, that truth is founded on objective facts. So our motto in our parliamentary republic, which is unitary federal, and that republic shows the objectivity. That republic is founded on objective facts. So our democracy is founded on objective facts. Their democracy is founded on faith, especially towards the religious affairs or especially towards the religion. So it has a close link of politics and religion, while India is completely and very effective and efficient secular state. So that way, that signifies that in Pakistan, politics and religion are linked, while in India they are separated. Our secularism, our religion, our religious freedom rights are completely separated from politics, and the state has the right to regulate or restrict our religious freedom. We do not have any state religion. So, from the viewpoint of the motto itself, we find a clear-cut difference between Pakistan and India so far as its democracy or so far as its secular character is concerned. The second aspect of Pakistan is that you must have heard that Chaudhry Rahmat Ali coined the term Pakistan, which is a land in which the pure abound. That is the meaning of Pakistan. The term was coined by Chaudhry Rahmat Ali, who was an activist of Pakistan movement in 1933, and finally Pakistan was created on 14th of August 1947. This is the newspaper of that day, Birth of Pakistan, an event in history. We are seeing the date, Delhi, Friday, August 15, 1947. And that is 27th Ramzan. So that day, Pakistan was created, and that created a history that India was partitioned and a new nation was born. So this Pakistan as a nation state started working from 14th of August 1947, that all of us know. A land where the pure abound. That is the meaning, literal meaning of Pakistan. And the term was coined in 1933 by an activist of Pakistan movement, Chaudhry Rahmat Ali. So literally it means a great thing, no doubt. It talks about purity. Pakistan, as I said, was created on 14th of August 1947. That was the 27th day of Ramzan. So it was also created in a month which is probably the most sacred in Islam. Once it was created, a question comes to our mind today, that why did Pakistan link religion with politics and army with politics? That is a serious question for us. We know that Pakistan was created on the ground of culture, religion, and probably that was the first example in the world when a nation was created on the basis of religion. So, we can say that there was a centrifugation in India, in the socio-cultural setup in India, and because of that centrifugation, Pakistan movement was initiated, and that led finally to the partition of India into India and Pakistan. So, the foundational event or foundational process of creation of Pakistan was centrifugation. And that centrifugation could have further, you can say, disintegrated Pakistan as a nation state, because minorities were also there. So, in order to prevent any future centrifugal forces to come up, Pakistan did two things. It wanted people to be very close to the religious affairs, and it also wanted to put pressure on the population by linking army with politics. On the other hand, if you look at India, Indian democracy was founded by separating religion and defense both from politics. And it was, in true sense, it was a people's rule. So, in Pakistan, as a nation state, democracy was founded not as a people's rule, rather, it got support in the form of two pillars. One was constituted by religious affairs, by the clergy, and the second was by the army. So, the government of Pakistan since then had always been under the influence of either religion or army, and that still continues. You can say Pakistan or creation of Pakistan was on because of these centrifugal forces. So, in order to prevent future centrifugation, politics was given the support from religion and the army. So, the army personnel or the chief of the army staff and the clergy became politically powerful, and that avoided common mass to come forward to the corridors of power, and the democracy was not allowed to function as a rule of the people or by the people. That was the foundation of democracy in Pakistan, supported by this religion and politics. So, in that sense, we can, if I sketch this, democracy in Pakistan, army, and that led to prevented the common man to enter the corridors of power. Hence, democracy could not be founded as rule by the people in true sense, unlike India. This was the situation when the democracy was created or founded in Pakistan. That's why we say that while India adopted a bottom-up approach or democracy from below. In Pakistan, it is democracy from above. That is the fundamental difference between the democracy in Pakistan and India. That is to be understood first. Now, let us come to the constitutional crisis and the changes in the constitutional development in Pakistan. Let us go back to the early 50s. Ghulam Muhammad was the Governor General after Jinnah, and Ghulam Muhammad fell sick. So, Iskandar Mirza took over as acting Governor General in 1955. In 1955 itself, he was, or we can say that in 1955, when Iskandar Mirza took over as acting Governor General, he was literally the fourth Governor General and last one also we can say. He was confirmed as fourth Governor General. And in 1956, when the country adopted its first constitution, he was declared as president. Once again, let's have a slide here, you can understand. Iskandar Mirza took charge as acting Governor General, and after adoption of the constitution became the first president in 1956. And what did he say? Separation of religion and politics, but he focused on a controlled democracy. Now, what does this mean? He could not separate religion and politics because of our motto in Pakistan to have faith, unity and discipline, faith towards the religion. So, religion was an inbuilt component or inherited in politics. So, the president could not segregate religion and politics. At the same time, he focused on controlled democracy, means it was, from political science viewpoint, we could say that it was an authoritarian democracy that way. And what could be the meaning of controlled democracy? What Iskandar Mirza suggested was that the executive must be appointed for a fixed term and it should not be dependent on parliamentary majority. So, parliament was reduced to simply a forum where the issues were discussed, and parliament was not allowed to function independently, what we see in Indian context. The cabinets were installed and removed as per the choice of the president. For example, first Prime Minister of Pakistan, Liaquat Khan, was not the choice of the Constituent Assembly. He was the choice of the president. So was Nazimuddin, the second Prime Minister. Maulana Nazimuddin was the second Prime Minister. He was also chosen by the president on his prerogative and on his discretion. So, parliamentary system, despite the fact that it created a parliamentary form of governance, but parliament was not allowed to function independently and cabinet was under the complete grip and control of the president. That was the foundation of democracy in Pakistan. So, we say that Iskandar Mirza took over as acting Governor General when Ghulam Muhammad, the then Governor General, fell sick, and finally he was confirmed as the fourth and the final Governor General of Pakistan, and he took charge as the first president of the country in 1956 when the country adopted its first constitution. But he wanted an authoritarian rule and he wanted a controlled democracy. First constitution of Pakistan in 1956. focused on controlled democracy. That means executive to be appointed for a fixed term and not to remain dependent on parliamentary majority. Now, this did not allow Parliament to function independently, and cabinets were installed and removed on the prerogative of the President. For example, cabinet under Liaquat Khan and also under Maulana Nazimuddin. So President Mirza was a kind of, you can say, authoritarian ruler. Following this, what he did, he abrogated the constitution because that did not allow him to establish a controlled democracy in true sense, which he wanted. So, he abrogated the constitution, and that was the foundation of martial law in Pakistan. This is the news of that period. You can see here Iskandar Mirza and General Ayub Khan, who was the chief martial law administrator. So, as the Dawn newspaper writes, Constitution abrogated martial law all over the country, political parties abolished, parliament, legislatures and cabinets dismissed. So, there was a complete dismissal of democracy in real sense. And this happened on 7th of October 1956. This is Wednesday, October 8, 1956. So 7th October 1956, he did that, and exactly after 20 days, he was himself ousted by General Ayub Khan. On 27th of October 1956, he was ousted by General Ayub Khan, who was then the chief martial law administrator, and after the ouster of President, General Ayub Khan declared himself as the president. This was the change in this. So, abrogated the constitution, martial law imposed, and then Commander-in-Chief General Ayub Khan took over as CMLA, that is Chief Martial Law Administrator. But On 27th of October 1956, President Mirza was ousted and General Khan declared himself the president. That was a major event that took place in Pakistan after its creation as a new nation state, which could have been a powerful, efficient democracy like what we have in India. But unfortunately, the linkage between politics and religion and the linkage between army and politics had shown its manifestation in this. And that was the first thing what we find here in the Pakistan's political developments. Now, the situation was so tense that the Supreme Court of Pakistan probably took a hasty decision, as most of the scholars in Pakistan they had written at that point of time, that the Supreme Court validated martial law in haste in a case State versus Doshu in 1958. Right? Earlier, what we could see that in Federation of Pakistan versus Maulvi Tamizuddin 1955, a new doctrine was interpreted by the then Chief Justice of Pakistan, Justice Muhammad Munir, which was referred to as Doctrine of State Necessity. So, let us understand this. This martial law was validated by the Supreme Court of Pakistan in State versus Dosu 1958. And it was alleged that this decision was taken in haste. In Federation of Pakistan versus Tamizuddin 1955, Doctrine of State Necessity was interpreted and made applicable in Pakistan by the then Chief Justice of Pakistan, Justice Muhammad Munir. Now, Doctrine of State Necessity tells us that the state may acquire, if needed, if a state necessity occurs, then the state may acquire, or the authorities may acquire, certain extra constitutional powers. So that laid the foundation of its misuse in future. So far as India is concerned, a state necessity doctrine is not applicable in general. But there is a case in 1996, Election Commission of India versus Dr. Subramaniam Swamy, in which the court has held that whenever you find that there could be a bias, in order to prevent that bias, which is an absolute necessity, you can restrict them, and that is called the doctrine of absolute necessity, which is which might be made applicable in India after this case. So, in Pakistan, this was the case in which, this was, we can say, very controversial case. This was the case in which the doctrine of state necessity was interpreted, and we find that this doctrine was first time misused by imposing martial law in Pakistan and abrogating the constitution. And that way, the president took extra constitutional powers, and that laid the foundation of weakening of democracy in Pakistan. Authorities may acquire certain extra constitutional powers if required. This is generally not applicable in India. It is in fact transformed into the doctrine of absolute necessity in order to prevent any possible bias. That is, to protect the natural justice. That is what we say, nemo in propria causa judex esse debet. You say absolute necessity protects the rule against bias, that is, thereby protects natural justice. It is unlike Pakistan. In Pakistan, state necessity will create a bias because it all depends upon the president or the authority concerned to grab or acquire extra constitutional powers, and which we had seen in terms of abrogation of the first constitution of 1956 and imposition of martial law, that extra constitutional power proved against the nation's interest or against the democratic principles. On the other hand, in India, we have transformed that doctrine from state necessity to absolute necessity in Election Commission of India versus Dr. Subramaniam Swamy. (1996) case. And this absolute necessity protects the rule against bias, which is one of the pillars of natural justice. So, that is again, this was the situation in Pakistan, which was very dangerous to the democratic principles. Then we have a series of martial law in Pakistan. In 1969, it was General Yahya Khan who became president. Then in 1977, Ziaul Haq, he also was the martial law administrator who became president. And finally, in 1999, General Pervez Musharraf also became the martial law administrator and then finally the president. So, in 1956, in 1969, in 1977 and in 1999, Pakistan has the history of imposition of martial law. First in 1956, General Ayub Khan was the president. Then we have 1969, General Yahya Khan. Then in 1977, Ziaul Haq. And finally in 1999, Musharraf. So we have a series of martial law in Pakistan, and that way it was, in true sense, it was a major jolt to the democratic principles. Although Ayub Khan wanted a new constitution and the constitution was created in 1962, but the 1962 constitution wanted a parliamentary form of governance, but Ayub Khan was not happy and he implemented presidential form of government in Pakistan, and that also led to the abrogation of 1962 constitution also. Second Constituent Assembly was set up in 1955 and 56, and as it is written, military dictator General Ayub Khan, who had taken over the reins of power, enacted the constitution to the country through an executive order. So this constitution was not given the nature of law passed by legislature. It was enacted by an executive order of the president, and that way it could not last long, and finally it was abrogated and replaced by the third constitution which we have today, that is Constitution of the Islamic Republic of Pakistan 1973, based on the recommendations of the Constituent Assembly 72-73. But the problem with the Constituent Assembly was that when it was created, it had the members or representatives both from East and West Pakistan. But in 1971, when East Pakistan was segregated and was formed into a new nation named Bangladesh, the Constituent Assembly did not have the representatives from there, and the representatives of the West Pakistan suggested or recommended for drafting the constitution, and finally it was drafted and was drafted in October 1972 and then brought into force from 14th of August 1973. So presently we have the Constitution of 1973. Now, one more thing I would like to point out here, that General Ziaul Haq between 1977 till his death in 1988, the concept of Islamization was made prominent in Pakistan, and he wanted to make the society work on the principles of Islam, and he also wanted to deliver justice through Islam, through religion. So politics and religion were intertwined more seriously and more powerfully during the reign of Ziaul Haq, and that probably has led to the growth of, or contributed at least to the growth of, radical Islam or radical people or radical groups in Pakistan, which finally led to the growth or emergence and growth of terror activities in Pakistan in the name of Islamization. We say that the Tehreek-e-Taliban Pakistan, you must have heard the name, Mullah Umar, who was the founder of Tehreek-e-Taliban Pakistan, believed in a philosophy called Neo-Islamism, and we can say this led to the emergence of Neo-Islamism by Tehreek-e-Taliban Pakistan, TTP, an outfit organization, a terror organization. What this says that Islam is not a religion, it is a political order also. Therefore, Islamization of society is essential, and for that, militarization of Islam is essential. This is the concept of Neo-Islamism. According to TTP, 3 points. Islam is not only a religion, but also a political order. Second, hence, Islamization of the society is essential. Hence, militarization of Islam is essential. And that is the manifestation of that radicalism which was introduced by General Ziaul Haq during his reign between 1977 and 78, and that had led, probably it has been a very major contributing factor for growth or emergence and growth of terror activities in Pakistan. That's why we say that terrorism in Pakistan has become a systemic problem. It is not superimposed. And when the problem becomes systemic, it is very difficult for the country to uproot it easily. It's a very difficult task. So Pakistan is faced with serious issues of terrorism in its own society, and it is very difficult for the state. Even if it tries very hard, it will be very difficult for the state to uproot it, because it is now a systemic problem in Pakistan. Now let's come back to the 1973 Constitution. Constitution of the Islamic Republic of Pakistan, 1973. Drafted on 20th of October 1972. Then ratified on 19th of April 1973 and enforced on 14th of August 1973. We have parts 12, articles 280, schedules 5 and amendments 25 until 2019. This is the structure of Pakistan's constitution. It creates a parliamentary form of governance having a bicameral legislature. Senate and National Assembly. This is the creation of Pakistan, but unfortunately, there were certain amendments which created, you can say, fragility, which brought fragility in Pakistan's constitution. One was the 8th Constitutional Amendment 1985. Then we had 17th Amendment in 2004, although we restored some of the things in 2010 by the 18th Amendment to the Constitution. The 8th Amendment 1985 to Pakistan Constitution gave the power to the President to unilaterally dissolve National Assembly. Eighth Amendment Act 1985. Empowered the President to unilaterally dissolve National Assembly. And I was referring in the initially I told you that Parliament was not allowed to function independently, and it was under severe vertical command of the President. That is the 8th Amendment 1985. Then the 17th Constitutional Amendment in 2004 Pakistan was made a semi-presidential form and parliamentary system was replaced. But fortunately enough, in 2010, by the 18th Amendment, it was restored. Parliamentary republic was restored. Restored to parliamentary form by 18th Amendment 2010. So that way it saved the parliamentary system, we can say. Then we have this is what we talked about so far. How Pakistan originated, why did it link politics with religion, why army and religion, and what were the manifestations that we had seen in terms of series of martial law in Pakistan, 1956, 69, 77 and 1999. During that period, we also discussed a very serious issue, that was emergence of radicalism during the Ziaul Haq's reign, that was in the form of Islamization, and that probably had contributed to the emergence and growth of new Islamism practiced by Tehreek-e-Taliban Pakistan. And that brought Pakistan before serious threats. Considering the 1973 Constitution, or in this backdrop only, we could look at now the present crisis which Pakistan faced recently, very recently. The first event in today's situation, what we could see on 3rd April 2022, a no confidence motion was to be introduced against the Prime Minister in the National Assembly, but the Deputy Speaker outrightly rejected it, saying that it had the hands of foreigners, or it alleged a foreign role in this no confidence motion. The Deputy Speaker also highlighted that this move by the opposition to introduce a no confidence motion against the Prime Minister was a gross violation of Article 5 of the 1973 Constitution, which says that loyalty is the basic duty of a citizen, loyalty to the state, and obedience to the Constitution and law is the basic duty of every citizen. So, the Deputy Speaker said that the opposition had shown disloyalty to the state, and introducing such kind of motion having a foreign role could amount to the violation of Article 5 of the Constitution. So, based on that, he rejected that introduction. That was the first event in the recent constitutional crisis in Pakistan, and that happened on 3rd of April. So, let us have one point in that. You can say recent crisis. 3rd April 2022. Deputy Speaker rejected the no confidence motion on the ground of alleged foreign role. Also stated that the opposition had or opposition violated Article 5 of the Constitution of Pakistan 1973. Now, Article 5, what it says? Loyalty to the state and obedience to the Constitution and law is the basic duty of all citizens. That was the first event on 3rd of April. Now, immediately after that, the Prime Minister advised the President to dissolve National Assembly, and the President complied with that advice. And that was under Article 58 of the Constitution. Now, the advice of the Prime Minister was given under Article 48(1). Let us see what the article writes. The second event, Prime Minister advised under Article 48 Clause 1 to the President to dissolve National Assembly, and the President complied with advice under Article 58. Now, Article 48 Clause 1 of Pakistan's Constitution says that the President shall act on the advice of Cabinet or Prime Minister. Means either Cabinet or Prime Minister. Now, when you say Prime Minister alone, then you have created a hierarchy. While in India, if you compare, the President shall act on the advice of the Council of Ministers, and the Prime Minister is appointed in India on the principle of primus inter pares, that is, first among equals. So, when Prime Minister advises the President alone, that does not have any significance. Article 74, Clause 1 of Indian Constitution says that there shall be a Council of Ministers to aid and advise the President. The Pakistan's Constitution under Article 48, Clause 1 says that the President shall act on the advice of Cabinet or Prime Minister. So, there is a subjectivity inbuilt in this provision, and that creates a suspicion. If Prime Minister is not happy, he might send his advice or tender his advice to the President to dissolve, what exactly Prime Minister Imran Khan did. And then under Article 58, the President complied with that advice and the National Assembly was dissolved. Now, in this backdrop, the Supreme Court took the suo motu action, and it said that the action by the Speaker was unconstitutional, and we can say unconstitutional, and probably this was the situation when some of the authors wrote that this was the time when we could say that Pakistan also saw a sign of constitutional coup, that the authorities took the power and they dissolved it, means they acquired the power within the constitutional framework. They did everything according to the provisions of the Constitution, but it was not in favor of the nation, it was rather against the state, against the democratic principles, or against the essence of the Constitution. So, that was the, you can say, that was the sense or sign of constitutional coup in Pakistan when the Deputy Speaker rejected it, saying that the opposition violated Article 5 and have shown disloyalty to the state and disobedience to the Constitution. Then the Prime Minister advised, who could have advised or who can advise, who is empowered to advise to the President under Article 48, Clause 1, and the President also did the same thing according to the Constitution under Article 58, and he dissolved the National Assembly. But the Supreme Court of Pakistan, after taking suo motu action, said that these actions or these acts committed by the Deputy Speaker and Speaker and the President was unconstitutional. And it said that the no confidence motion must be introduced and it must be voted on. This is what the situation was in Pakistan, which led to a kind of constitutional coup or constitutional crisis. Now, what are the things under question? We are seeing this diagram. Pakistan's government is within the jaw and democracy is perturbed. Provisions of the Constitution in question and the role of different institutions. People have said that Article 6, which talks about high treason, and the Prime Minister Imran Khan should have been charged of that. Although the Supreme Court has cleared him that he is not charged of high treason, but what Article 6 says, any person who abrogates or subverts or suspends or holds in abeyance or attempts or conspires to abrogate or subvert or suspend or hold in abeyance the Constitution by use of force or show of force or by any other unconstitutional means shall be guilty of high treason. So, the opposition wanted the court to charge Prime Minister of high treason under Article 6, but the court had given him clean chit. Why? Because it was not unconstitutional means, because Article 48, Clause 1 empowers the Prime Minister to give advice to the President to dissolve National Assembly. So, he was given that clean chit, but that is a major issue in Article 6 of the Constitution of Pakistan. Then 69, courts not to inquire into proceedings of Majlis-e-Shura, that is Parliament. The validity of any proceedings in Majlis-e-Shura shall not be called in question on the ground of any irregularity of procedure. What we have in Article 121 and 122 of the Indian Constitution, we also have the same, you can say, provision that the court shall not intervene into parliamentary proceedings. And second, the parliament shall not discuss the conduct of a judge unless the resolution to remove him is under consideration. This is our provision. Similarly, Article 69 of 1973 Constitution of Pakistan prohibits the interference by the court in parliamentary proceedings. But the critics have said that since the court has taken suo motu action and has asked the party or asked the state to introduce no confidence motion and vote upon that, that is a kind of interference in the parliamentary proceedings. So, the court itself has violated Article 69 of the Constitution. That is the allegation on the Supreme Court of Pakistan. Now, whether it is true in case of India? Supreme Court cannot interfere in the parliamentary proceedings, we know in India, but the Constitution of India under Article 142 gives inherent power to the Supreme Court to deliver complete justice. So, in that case, if the Supreme Court feels that any of the acts committed by Parliament or either House of Parliament which might lead to the violation of the Constitution, it can draw that inherent power from Article 142 and save the country or save the democratic principles based on that. So, definitely we also have separated legislature and judiciary, but there is a possibility of making a check and balance. So, Indian Constitution really works on striking a balance between powers and authorities, and it also has a very powerful and efficient system of checks and balances, which probably the Constitution of Pakistan lacks. That's why we say that constitutions of such nature are called fragile constitutions, because they are unable to give clear-cut direction at the time of crisis. On the other hand, the Constitution of India is considered to be enlightened and a stable constitution, and it is capable of giving guidelines to resolve all kinds of disputes and conflicts. So, that was Article 69, a charge, an allegation on the Supreme Court of Pakistan. And finally, Article 95, that vote of no confidence against Prime Minister. A resolution for a vote of no confidence moved by not less than 20% of total 49 words 7 and 8 substituted by the Constitution, 18th Amendment Act, inserted by the Constitution. A resolution referred to in clause 1 shall not be voted upon before the expiration of 3 days or later than 7 days from the day on which such a resolution is moved in the National Assembly. So, this is the provision in the Constitution of Pakistan, that is Article 95, which talks about no confidence motion. Article 69 separates legislature and judiciary by preventing the court from interfering in parliamentary proceedings. And then Article 6 talks about high treason, and Article 5 talks about loyalty to the state as the basic duty of the Constitution. So, that way the constitutional crisis finally, somehow or the other, by interference of the court, it has been resolved, and the new government under Shahbaz Sharif has been installed. Now, these developments in Pakistan, how could they impact India? India and Pakistan have not been able to strengthen their relationship for 2-3 reasons. The primary reason is more cultural than political. This is why, because when we take the name Pakistan, we go back to pre-independence period, and we find that the cultural traits, the cultural aspect, the religious aspects were the prime factor to partition the country, and that creates a kind of hatred in the eyes of Indians, or probably in the eyes of Pakistanis also. So, the mutual trust which could come from the cultural traits, the mutual trust is probably missing, or is at very, very low level. That's why we are not able to trust each other. So unless and until we have three levels, we cannot have good relationship. What is that level? One is understanding, then trust, and then friendship. So we do not have true understanding between these two countries. So what do we need? We need peoples to people contact to understand each other. Then only we can develop trust. So this is missing in between India and Pakistan. That's why we are unable to have friendly relations with the neighbor. And probably it is the same thing for Pakistan also. It doesn't trust India, so it does not have the courage to, or it doesn't have the intention to develop friendly relations. The second aspect, which is political, is the territorial dispute, or we can say dispute over the sovereignty of Kashmir. So that is one of the probably the biggest hurdles between India and Pakistan relationship. Now these developments in Pakistan, which makes the state weaker from inside, that or fragile from inside, that might contribute to the strengthening of outfit organizations. And these outfit organizations may come forward to play greater role, non-state actors what we call sometimes. They might play greater role in handling the situation, and that way insecurity, the sense of insecurity is more for both India and Pakistan, because these crisis like situations or crisis always make the state fragile, and fragility of state will strengthen the outfit organizations. So in that case, we need to be very, very strong and very particular, very agile and active so far as our internal security architecture is concerned. So that is the possible impact of these developments between India and Pakistan. Third, although we do not have a trade agreement with Pakistan in real terms, but whatever trade we have, that might also be affected because of the sense of insecurity. So both the nations need to come forward, forgetting these crisis like situations, and we are not supposed to interfere in Pakistan's internal affairs, but we need to propose the peace steps which our Prime Minister has done, and India has proposed for peaceful relations with Pakistan when the new government is in the corridors of power. So it is hopeful, we are hopeful that Pakistan would also respond in a positive manner and peace will be encouraged, because India has always believed in security in peace, not peace in security. Both the nations are nuclear weapon states, but India does not want peace in security. India wants security in peace. So we are peaceful nation and we are non-aggressor. So it is the high time for both the nations to come forward to encourage peace and work on confidence building measures. So I think what I have talked to you would be sufficient enough to have your understanding on this, how Pakistan had seen a constitutional crisis over the period, how Pakistan has damaged, basically, let me put it this way, the democratic principles, and democracy needs to be revisited in Pakistan, and definitely by all means Pakistan needs to correct certain things so far as its laws or constitutional provisions are concerned to strengthen the democratic principles, because democratic principles as well as religious principles need to be balanced properly for the state to function smoothly. Thank you very much.